All right, YouTube. I'm Vince White. I'm an employment attorney. This was a pre-recorded video because I'm traveling right now, so forgive me. I am answering a publicly posted question that was posted on looks like June 7th of 2022. The question was posted by YouTube user Jay Hefner. And I have already created a video answering the first part of this question, but I will read the question for our purposes here in the second part. I'll read the question into the video again. Jay Hefner asks, question, my lawyer has appeared to back off on a case even though he says it's in good standing. It is a multiple plaintiff case, so the lawyer is representing multiple plaintiffs. And plaintiffs are the people complaining, right? They're the people bringing the case. Defendants are the people who did something wrong, potentially, allegedly, and they're having the case brought against them. The case is against a monopoly, multi-million-dollar company, and a few of the clients think he is bought, but there's no evidence of it. And that line right there is the line that I made my first response to, because I hear that about lawyers being bribed all the time. So I posted that video yesterday, and I hope it was useful. Let's go on to the second part of the question. Is there a way we can demand the attorney do a deposition as all of the plaintiffs have sat for our depositions? We're just waiting on him to depose some of the employer's witnesses. Do we need to request this in writing? Sorry this is lengthy, but it's a lot going on. Okay. So, couple thoughts here. You do generally want depositions. There are limited circumstances. There are situations where the lawyer might say, hey, I don't think I need depositions. That can happen. It is rare. All right. I think it happens in probably less than 10% of our cases where we look at it, we're just like, yeah, I don't think we necessarily need a deposition here, given that people are, I mean, one of the ways that happens is people are just completely pinned down by recordings or written documents, and we're just not super concerned about various evidentiary findings. Also, sometimes what you can do is sometimes lawyers will enter into a tolling agreement for discovery if the judge is cool about it. And by if the judge is cool, I mean if the judge consents. The judge is in charge, right? The judge is going to set the schedule if you're in federal or state court. So like sometimes if you're closing in a settlement, you'd enter a tolling agreement to wait for depositions. Now, I always caution our attorneys to be a little bit leery of these tolling agreements because often what employers will do, what defendants will do, what defense counsel will do, is say, hey, we should talk settlement. Really, like, talk settlement like right now. And you got to pay attention because if you're deposing high-level people or if you're deposing people who might reveal something like a bombshell for your case that's incredible for your case, that will increase the value of your case, often what defense attorneys will do is they'll try to settle the case before that deposition, right? Companies coming up on IPOs, initial public offerings, companies coming up on sales or mergers, companies with high-level executives that they don't want to expose to being questioned. All of these companies will often flinch in litigation right before you start to get the right to depose people. And they'll say, hey, let's have a mediation. Let's talk how many zeros on the check. Let's not be crazy, right? Let's not. I think that we can, there's this famous book called Getting to Yes that a lot of mediation clinics will push, right? It's a good book. It's a good book about getting people to agree. But you'll often hear people who've read the book like quoting from it verbatim like robots, like, I just want to make sure you're feeling heard. Okay, well, thank you for talking like an alien. I was feeling heard, but now I feel like you're a mediation robot. I don't understand what's happening, right? But you'll start to hear from these defense counsel like lines from the book, like, I think we can talk about just getting to the middle here, getting to yes, right? Everyone should leave unhappy. That's what mediation is. Okay, you're just quoting chapters. Like, what are we doing here? Like, I get it. I get it. You want to get this done, all right? Just say that. So watch out for that. I guess one of the things you could do is ask your attorney as a group, get the plaintiffs together as a group and ask your attorney in writing to be like, hey, can you tell us your rationale for why you're not doing depositions? How long do you have to do them? When do depositions have to be done by? Who do you intend to depose? And why not these people, right? If there's people that you want deposed that the attorney's not going to depose, okay, put in writing why not. Tell us why you don't want to depose that person. And, or even better, tell us why you don't want to depose anyone if that's what's going on, right? And demand it in writing. Demand it in writing, right? And if the attorney won't do that, if the attorney's like, no, I'm not going to answer your question. First off, garbage attorney, it's our job to answer questions to our clients. That is part of the duty of loyalty. Communication is part of what we do. Second off, very concerning that this attorney won't explain her or himself to you, the client, when it comes to the tactical stance of the case, the plan, right? So I would say your next step should be, hey, we all want to know what the plan is going forward. Who's getting deposed and why? And who isn't getting deposed and why? We want that answer in writing because there's a lot of us and it's going to make sense to give it all to us in writing. And if that lawyer flinches, if that lawyer is like, no, then you might want to have a conversation with another attorney. You might want to get all the plaintiffs together and be like, hey, this is deeply concerning. This lawyer does not appear to be doing the things that she or he should, and we need to get a second, a third, and a fourth opinion here, because this is, at this point, getting scary. And I know I made a video yesterday saying it's unlikely your attorney was bribed, but I will say, if your attorney refuses to give you the written rationale for who's getting deposed and why not, bribe or no bribe, I would at least say, I'm concerned at that point. At that point, I would be concerned and I would have questions. And if you end up in that position and you have questions and your attorney's not answering, feel free to post on this video. I'll track the comments in the video and I'll try to be responsive to you. I hope this was helpful. I hope that you win lots of money and all your plaintiffs are made whole and your attorney is doing great things and it's all going to work out. But if it's not, I will be here to answer your questions to the extent that I'm allowed by law. Remember, I can't answer state law questions. I can only answer in generalities and federal laws in terms of discrimination and sexual harassment in the workplace. And if you think this was helpful, consider liking and subscribing because I am required to say that because I think it's supposed to be good or something. Good luck. Good luck, Jay Hefner. I am rooting for you.